Imagine you receive a massive bill from the government. You spend days painstakingly digging through your records, compiling a mountain of evidence in your defense, and you submit it right before the final deadline. But the exact second you do, the official stamps guilty. They finalize your penalty without reading a single page. That exact sequence of events recently played out between the Indian Income Tax Department and Pricewaterhouse Coopers, PwC. The government issued the firm a staggering tax demand of 87.20 crore rupees for the 2024-25 assessment year. The assessing officer driving this massive penalty was operating under intense institutional pressure. They were racing against a strict statutory deadline, a hard legal cutoff to close the case on time. In the eyes of the law, what holds higher authority? The government's need to hit its internal bureaucratic deadlines, or a citizen's constitutional right to a fair hearing? To understand how a procedural deadline derailed an 87 crore tax case, we have to look at the timeline. Initially, PwC's tax return was flagged for routine scrutiny. The case was transferred to a jurisdictional assessing officer, and PwC participated at every step. Through multiple rounds of notices, the company provided detailed explanations, financial records, and all the supporting documents requested by the tax authorities. Then came a sudden disruption. On March 28, 2026, the assessing officer issued a brand new show cause notice. This document introduced fresh, complex allegations regarding consultancy fees tied to a specific corporate acquisition of KSK Energy. The tax department gave PwC a highly compressed window to respond. The firm had exactly 48 hours to explain the nuances of these newly questioned transaction fees. This timeline charts the final stretch. PwC submitted a comprehensive, evidence-backed reply on the deadline, March 30th. But that exact same day, the assessing officer issued the final 87 crore tax demand. Zooming in, we see a mathematical impossibility. A dense defense went completely unread. PwC took the dispute straight to the Calcutta High Court, filing a writ petition under Article 226 of the Constitution to challenge the validity of the assessment. The Revenue Department defended their actions with a technical argument. They claimed PwC had already been given plenty of opportunities to speak earlier in the year. Plus, they argued, they were legally forced to issue the final order that day to stop the statutory time limit from expiring. PwC countered that past cooperation was entirely irrelevant here. Because the March 28th notice introduced brand new allegations about the KSK Energy deal, the assessing officer had an absolute legal obligation to evaluate their specific defense against those new claims. The legal doctrine at the center of this clash is natural justice, or prakritik nyaya. Judicial precedent dictates that the right to a hearing must be genuine and effective. It cannot be sidelined just because a ticking clock makes it inconvenient. PwC argued that because the assessing officer lacked the time to actually read their final reply, the procedural opportunity to be heard was rendered entirely meaningless. The High Court was left to decide a very specific question. Does an impending bureaucratic deadline give the state the legal cover to ignore a citizen's submitted defense entirely? The Calcutta High Court ruled decisively against the Revenue Department. They quashed the entire assessment order, wiping out both the 87.20 crore tax demand and the associated penalty proceedings. The judges laid out a clear philosophical boundary. They ruled that the formal, technical issuance of a show cause notice does not satisfy the law. If the taxpayer's explanation isn't objectively considered, the legal requirement hasn't been met. Looking directly at the timeline, the court noted that passing an order on the exact day the reply was filed reduced a fundamental legal safeguard into a mere ritualistic formality. This establishes a firm precedent for how tax cases are handled. Administrative convenience cannot override a taxpayer's substantive legal right to procedural fairness. For PwC, the court remanded the matter back for fresh adjudication. The tax authorities are now legally forced to provide a genuinely meaningful hearing before they can issue any new order. For the broader system, the judgment serves as a strict warning. Hurried, copy-paste assessments, finalized merely to beat an internal clock, are highly vulnerable to being struck down in court. In the ongoing friction between state machinery and individual rights, this ruling stands as a reminder that the courts actively guard procedural fairness. It ensures that the power to tax remains subject to the strict rules of natural justice.